Good morning, this is your Kelso Report for Wednesday, March 14th, and I'm your host, Clark Kelso. We have cases today dealing with search and seizure, the Freedom of Information Act, insurance bad faith, government personnel actions, and taxes. Let's begin with the Ninth Circuit and a search and seizure case. Last year, the Ninth Circuit held in United States v. Baker that suspicionless search conditions for probationers do not violate the Fourth Amendment. In Baker, the defendant challenged a condition of probation subjecting him to search, quote, with or without probable cause and with or without reasonable suspicion, close quote. Based on this condition, the court concluded that a suspicionless search of a probationer does not violate the Fourth Amendment. In yesterday's case, United States v. King, the panel slightly extended that holding to a warrantless and suspicionless search where the condition of the defendant's probation provided that he was subject to a warrantless search, quote, with or without probable cause, close quote, but did not expressly say with or without reasonable suspicion. The panel concluded that the absence of that phrase didn't make a difference because the plain import of defendant's probation condition, allowing warrantless searches at any time, is that the defendant may be searched whether or not police suspect him of wrongdoing. Either way, it doesn't matter. You can have a suspicionless search as well as one without probable cause. Next, a Freedom of Information Act case. The Freedom of Information Act is not supposed to be a substitute for ordinary discovery once a matter has landed in litigation. Yet that is exactly what two taxpayers tried to do in Shanahan v. Internal Revenue Service. The taxpayers were indicted for filing false tax returns, but they fled the country. The IRS then opened a civil investigation and concluded the taxpayers and affiliated companies owed substantial sums in back taxes. The lawyer for the taxpayers filed a FOIA request for documents relating to the taxpayers, which the IRS refused to disclose. The district court denied the FOIA request, concluding that disclosure would seriously impair federal tax administration, within the meaning of Exemption 3 of FOIA, and that disclosure could reasonably be expected to interfere with enforcement proceedings, within the meaning of Exception 7A of FOIA. The Ninth Circuit easily affirmed, noting that the fact that the taxpayers wish to use the documents they seek in their civil tax proceeding does not make Exemptions 3 and 7A inapplicable. Indeed, it is precisely because of the uses to which the taxpayers might put the documents that the exemptions are applicable. In short, if the taxpayers want to litigate their cases, they must use the ordinary rules of discovery and not try to do an end run around those rules using FOIA. Next, an insurance bad faith case. Now, case law in California has established that an insurer has a duty to accept a reasonable settlement offer only with respect to covered claims. That is, a claim for which the insurer owes the insured a duty of indemnity. Now, I'm sure we all recall that the duty to defend attaches more broadly with respect to claims that are potentially within the insured's policy. But refusal of an offer to settle supports a bad faith action only if the claim is a covered claim. Well, in DeWitt v. Monterey Insurance Company, the plaintiff tried to submit a bad faith claim to the jury without establishing as a matter of law that the claim was a covered claim and without tendering to the jury the issue of whether the claim was a covered claim. Apparently, the plaintiff's theory was that a refusal to settle could be the basis for a bad faith action, so long as the claim was possibly within the scope of coverage. You didn't need to prove that it was within the scope of coverage. Well, the trial court disagreed, and absent any argument that the claim was a covered claim, the jury found against the plaintiff. The Fifth District affirmed. Essentially, plaintiff's attempt to expand the bad faith action to encompass refusals to settle in cases where the insurance company has no duty of indemnity was rejected by both the Superior Court and the Court of Appeal. And I don't think the plaintiff will have any greater luck on this with the California Supreme Court. Next, we have a case involving personnel actions in the public sector. In Cate versus State Personnel Board, the 4th District affirmed the decision of the Superior Court to grant a writ of mandate directing the State Personnel Board to reinstate the termination of a prison custody officer formerly employed by the California Department of Corrections and Rehabilitation. Among other abusive actions directed at inmates, the officer told a mentally ill inmate who was threatening to commit suicide, quote, "Go ahead and hang yourself," close quote. Believe it or not, the State Personnel Board's ALJ had reduced the termination to a 30-day unpaid suspension, which the Personnel Board affirmed. But the Superior Court in 4th District decided that the Board abused its discretion in approving that reduction. As the Court explained, this is not a case where reasonable minds can differ with regard to the appropriate disciplinary action. The safety and physical integrity of inmates is one of the officer's paramount responsibilities. Lastly, a taxes case. We close with a tax ruling from the 2nd District in Taiheyo versus Franchise Tax Board. Construing Revenue and Taxation Code Section 23612.2 narrowly against the taxpayer, the court concluded, the 2nd District concluded, that the sales and use tax credit of Section 23612.2 is not available in connection with the purchase of current expense assets, but only applies with the purchase of capital assets, because the definition of a qualified property in the statute refers to the terms placed in service and basis, and those terms are used generally with respect to capital assets only. In short, taxpayer loses and the Franchise Tax Board wins. And with that, have a great day in the law.